So what is wrong with you? She picks you up and brings you back home, and then you beat her up. Do you love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then punishment is anywhere from 2 to 20 years in prison. Do you want me to put you in a corner and hit you? I think not. So that shouldn't be done to a child either. You understand?
Yes, Your Honor.
Okay, Mr. Burbank, while she's checking that, you may proceed with argument.
Your Honor, at this time, I'd like to call the probation officer real short, couple questions.
Sure. Good morning, Ms. Carthen? No.
Ms. Malver.
I'm sorry. Would you please raise your right hand? That's
State versus Alfredo Campos. Could I have parties announced? Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Mr. Campos, did you review the true bill of indictment with your attorney? Did you understand it? All right, in count 2, you're charged with assault family household member with a previous conviction. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
in my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as a primary custodial parent?
Yes, sir.
Right. Knowing that, do you still wish to continue with this plea?
Yes.
Right. Then to the offenses charge, how do you plea in count 2? Guilty, not guilty, or no contest? State, any evidence?
This time state the evidence states exhibit 1 with all attachments.
No objection.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
All right. So what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stay in there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue?
I think you should.
Yeah, I mean, you do. Because somebody who, do you love her, or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then, all right, let me tell you what's in the police report, and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
Or I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point, and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from ISF, not from the county jail.
Oh, okay, so there was no bond posted. Okay, that's what I think.
So here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos, she has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today. So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, aka Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her, because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But if you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship, because with orchids, you have to learn patience. You understand? All right, good luck to you.
Thank you.
You're welcome.
Just have a seat up there.
Court is calling 2021 CR 9284, State of Texas versus Elizabeth Yepes. Go ahead, parties announced for the record for the state.
Ryan Grimmer for the state of Texas.
For the
Robert
defendant.
Mauer for defendant.
And are you Ms. Yepes?
Yes, sir.
Ms. Yepes, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, sir.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Yepes, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We're not, Judge. There's 2 counts on there, Judge. We proceed on count 2, and we would waive the enhancement allegations. We would also waive count 1. Count 2 is a second-degree felony, straight possession, 4 to 200 grams.
Any objection?
No, Your Honor.
Ms. Yepes, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Did you understand the state is proceeding on count 2? And that charge is possession of a controlled substance, felony group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is.
Ms. Yepes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea bargain agreement?
no.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes.
Next, I'm showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, sir.
According to the plea bargaining agreement, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. The state opposes your application. Did you understand with a felony conviction, you will not be allowed to own or possess any weapons or ammunition?
Yes.
Did you also understand if you have a question of what a weapon or ammunition is, you'll need to speak to an attorney?
Yes.
Did you understand that to be the entirety of the plea bargaining agreement?
Yes.
Defense, is that the plea bargaining agreement?
It is, Judge.
State, is that the plea bargaining agreement?
Yes, Judge.
Court will find the defendant has knowingly and voluntarily waived her right to jury trial, showing you what's entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
The judge, there was a motion to suppress, was denied by Judge Angelini, and we reserve our right to appeal that.
That's part of the plea agreement, Judge. We're allowing them to retain their right of appeal, only for that motion.
All right, and the court sees that outside the plea bargain agreement, state agrees to allow the defendant to preserve the right of appeal on a motion to suppress that took place on April 18, 2022 and April 19, 2022. And the court will note for the record, you will have, if I follow your agreement, you will have a limited right to appeal, and that right to appeal will be as it relates to the motion to suppress. Do you understand?
Yes.
All right, then to offensive count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
Any objections?
No, Your Honor.
Mr. Yepes, Ms. Yepes, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. And Ms. Ferguson, on this case, I'm going to need a sentencing date, please. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. All right, so we're going to come back on July 25th at 9 a.m. for sentencing. Ms. Yepes, the court will make its decision on your application based upon a report I received from probation and any other evidence that's presented to me on that date. Do you understand?
Yes, ma'am.
Mr. Mauer, is there a need for a TAP evaluation?
I'd ask them to be done, Judge.
And Rebecca, there's going to be a TAP evaluation.
Yes, ma'am.
All right, the probation officer is here and back. She'll go over everything that needs to be done, but do not leave before you get a reset form.
Yes, ma'am.
All right, if there's nothing else. All right, so we have an issue. And the issue is that you're not making your appointments. Is there a reason for that?
For the center or?
Everyone needs to whisper, please. What I'm seeing is that there are a lot of non-reports for you. I understand the issues that you're having, but you must report. Do you understand?
Yes, Your Honor.
So what's going on?
Your Honor, via Zoom or in person?
Just, I mean, you have all these myths. And you have compromise. I put you on the drug patch. And there's positives for methamphetamine. And then you didn't get the drug patch for from November 1st to November 24th, no drug patch. From March 3rd through March 24th, methamphetamine. May 18th, you failed to submit. December 8th, 2021, failed to submit. January 25th, 2022, you're admitted to using methamphetamine. So what is the issue? What is going on in your world? Why are you doing this?
Your Honor, besides the drugs, the reason I didn't turn in patches for an extended period of time is because me and my family go on trips. My dad has a boat. And my parents have an RV, so around Halloween we were gone for about maybe a month. So It's just trips.
Well, here's the thing. Unless, and I'm not being mean, but unless you want your next trip to be to the prison, you're gonna have to start getting your life together. You understand?
Yes,
Do you
sir.
understand how much time you could be facing in prison?
No, Your Honor.
20 years. You understand?
Yes, Your Honor.
And that would be me deciding on whether to sentence you up to 20 years in prison. So you can start making your appointments, or you can say, I'm done, I don't want to do this, and then you can go to prison.
Yes, Your Honor, I'd like another chance.
All right, so let's not come back here again for you not reporting, not following through on what's asked of you.
Yes, sir.
Now, it sounds like there is an issue with your abilities not to use drugs, and an issue with you not following through with your mental health issues. So you're gonna have to start doing that. If you don't, how much time could you look at in prison?
20 years in prison, Your Honor.
All right, and up to a $10,000 fine. Now, the $10,000 fine, people usually don't worry about that. It's my liberty is taken, I'm at the prison. Because at the prison, you won't be able to go to trips wherever you're going with your parents. You understand?
Yes, Your Honor.
So they want to see about placing you in safety. I'm going to give you one last chance to get your life together, to take testing, to get on track with your drug treatment and your mental health issues. Do you understand?
Yes, Your Honor. Thank you.
All right. So if you're drug tested today, before we even do it, what are the results going to be?
Methamphetamine takes 3 years to get out.
No, it does not take 3
I'm
years.
sorry, 3 days. I'm sorry.
So when was the last time you used?
Since before I submitted,
No. When's the exact day, the last time you used? You should know this.
I'd say less than a week. But
All right, and who were you with when you were using? I know it wasn't your parents.
I was with my friend.
All right, so that's not your friend. And you know how I know that's not your friend? Because your friend should know personal things about you, right? So does your friend know that you're on probation?
Yes, Your Honor.
Then your friend should know that you're looking at 20 years in prison if you don't follow through on what's being asked of you. And he or she should be telling you, don't do this because you could go to prison. So since they're not telling you that, that's not your friend. You understand?
Yes, Your Honor.
When's your next appointment for your mental health?
Your Honor, I don't know the date.
All right, do you have an appointment upcoming?
Your Honor, I believe we have an appointment card.
All right. Do you keep up with your dates, or do your parents keep up with your dates?
My father does, Your Honor.
All right, how old are you?
25, Your Honor.
All right, you're gonna have to start getting you a calendar. They're on sale now because a majority of the year is gone. You can get the big calendar for $4.99, it's probably $2.99 now, and you can get the handheld calendar. I personally, I know people put stuff in their phone, but I put everything in this calendar, everything. So you need to get you a calendar, and if you get one of these calendars, because they're on sale, because half the year is almost gone, you can probably get one for $2.99. You understand?
Yes, Your Honor.
So you need to start putting everything in that calendar and carry it around with you, because if you miss some more appointments, what's going to end up happening is a motion to revoke is going to be filed. And what's going to happen when a motion to revoke is filed, if it's in proper legal order, I'm going to sign it. A warrant's going to be issued for your arrest. You're going to be picked up wherever you may be, at your house. You could be in line shopping for groceries. You could be on the RV with your parents. They're going to take you into custody. If you're out of county, in county, doesn't matter. They're going to take you into custody. Ultimately, you're going to get transferred to the Bear County Jail. Then your parents are either going to bond you out or not bond you out. Attorney is either going to be appointed to you, and you're going to hire one, and we're going to hear your case, and I'm going to make a decision on whether or not you're going to prison for 20 years. You understand?
Yes, Your Honor.
So this is what I want him to do, Rebecca. I'm going to want him on the UA hotline. That's going to help you with your times, because you have to call them every week. If he misses calling a UA hotline, a warrant is going to be issued because a motion to revoke is going to be filed. You understand?
Yes, Your Honor.
Now, again, if you don't follow through on this, how much time are you looking at?
20 years in prison, Your Honor.
All right. And let's give him intensive outpatient treatment. Obviously, he needs drug help. All right. Good luck to you. I'm gonna notate in this file, this is another thing, now keep it on, I'm gonna notate in here that we had this discussion about your drug use, about missed appointments, and that I'm telling you that you're on the UA hotline and that you're in intensive outpatient treatment. And Rebecca, can you make sure that they're doing field visits for him? And let's do field visits 2 times a month random.
Yes, ma'am. And if you can just remind him, he needs to make sure he tells his officer when he leaves on his camping trips. If he's leaving Bear County, he needs permission.
All right, so anytime you're leaving Bear County, you need to get permission. Do you understand?
Yes, Your Honor.
If you leave Bear County and they find out about it, which usually they will, what's going to end up happening again is a warrant may be issued for your arrest. If I review the motion to revoke and it's in proper order, a warrant's going to be issued. You understand?
Yes, Your Honor.
All right, so how much time could you be facing if you don't follow through on what I'm telling you?
20 years in prison.
All right, just have a seat, probation. We'll go over conditions with you, okay?
Yes, Your Honor.
You're charged with the offense of injury to a child, bodily injury intentionally and unknowingly. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
I understand, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defense to this offense?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. White, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. You reviewed that page with your attorney. Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 2. Punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. There are no applications. The state will take in consideration 2021 CR 11250. There's an affirmative finding of family violence. You plea as a co-defendant with Kayla White, Kayla Connor, and Christopher White. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Judge.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Well, there's been filed motions, but they hadn't been ruled on, Judge.
And Mr. White, to the offense as alleged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Yes, Your Honor. At this time, state offer states exhibit number 1 and its attachments.
No objection.
Mr. White, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please, Judge.
Anything you wish to say on behalf of your client?
No, Judge, other than we respectfully ask that the court follow the plea bargain agreement, as decision was difficult to make on behalf of Mr. White's behalf. And, but considering all circumstances, he's agreed to take responsibility.
All right, so I'm going to follow your agreement, sentence you to 4 years in the prison. Give you credit for any time served. There's an affirmative finding of family violence. When you entered your plea as co-defendants, I'm sorry, as co-defendant with Kayla White, Kayla Connor, and Christopher White. And Mr. White, do you admit that this act was committed with Kayla White, Kayla Connor, and Christopher White?
I don't believe that my brother or my sister-in-law, Kayla White, had any involvement.
You're pleading as a co-defendant, so that's my question to you. According to this plea bargain agreement, you're pleading as a co-defendant.
I don't understand.
You want to speak to him about that?
Maybe just rephrase the question.
All
Well,
right. You understand that Kayla White is a co-defendant in this case?
Yes, I understand.
All right. So you understand, according to your plea bargain agreement, you agree that she is a co-defendant
Yes, I
and
understand.
partially responsible for this. Do you understand?
I can't make a plea for somebody else's guilt.
Judge, I think what we understood is that he would, that with regard to any other co-defendant who has not pled, and there should be 4, but I think only one has done a plea. That's Kayla Connor. I think she got a deferred deal. The other 2 co-defendants, I don't think have pled to my knowledge, but
I
Should-
can't
should
speculate their involvement, Your Honor.
well, should Mr. White be a witness in that case and be called to testify, he could testify as to what his personal knowledge is. That's what he thinks he's agreeing to do here.
Yes, Judge, and there's from speaking directly with the defendant, he claims to have no knowledge specifically, but there's potential that we might call him as a witness if the other 2 defendants were to go to trial, that being Kayla White and Christopher White, and that is in contemplation of that particular provision of his plea bargain agreement.
Do you understand that, Mr. White?
Yes, I understand. Yes, Your Honor.
All right, as previously stated, the court has sentenced you to 4 years in the prison, credit for any time served, affirmative finding of family violence. You're pleading as a co-defendant with Kayla White, Kayla Connor, and Christopher White, taking in consideration 2021 CR 11250. Is there anything else from either side with regards to sentencing?
I know you want.
Let me see.
All right, I'm going to show you what's entitled trial court certification. Thank you. A defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand? You understand?
Your Honor, does the law change after 5 years after the end?
You're not allowed to possess any weapons or ammunition due to the fact that this is a felony conviction and also because there's an affirmative finding of family violence. I need to know whether or not you understand that.
I understand.
All right, if you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. White, possessing a weapon and whether or not you can possess one should be the least of your concerns. Your concerns should be about this child who now doesn't trust you and you haven't been a good parent to that child. So that child doesn't have its mother because that child stated in the police report, they haven't seen their mother in who knows when. People need to stop having children if they're not going to take care of them appropriately. People need to stop having children if they are not going to show them the love and respect that they deserve.
Yes, Your Honor.
Now, do you want me to put you in a corner and hit you? I think not.
No, Your Honor.
So that shouldn't be done to a child either. You understand?
Yes, Your Honor.
All right, and before you decide to have any more children, I would suggest that you take parenting classes and learn how your actions impact the child and how that diminishes a child's self-esteem. And then, you know what ends up happening? When your child decides to have children, hopefully they won't treat their child the way you treated them, but you never know. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, everyone.
Okay, let's see, sentencing on Kevin Ross.
Judge, we need a little clarification from the court. We're kind of both semi-confused on, I think the court originally rejected 5. And so we went back to a cap of 8. Is that what you reflect also? Or then open on the MTRPs?
I mean, I don't have anything other than the new PSI in front of me. So was there already a PSI done? When I rejected something, or?
No, it was just an original plea for time without a PSI.
And I was supposed to say, if it's a cap of, why would we have an updated PSI if it was in grade 8?
Oh, no, I think that's a mistake.
think it's a-
I have a question about that. I said, why a PSI if it was agreed? Is it a cap?
Right,
And so I would,
Sorry.
we can look back. Can you pull up Kevin Ross's please papers or send them to me so I can see
You want us to sit back and?
no, but do it real quick. Cause number 25 DCCR 1310. We can just double check what you guys signed. No, it's a cap of 8. That was just a.
Thank you.
Okay. And yeah, actually go ahead and I just want to make sure if it's a cap of 8 on all 3. I don't know why it wouldn't be. Okay. All right. So it was a cap of 8 on 5 on 3. So sir, you are Kevin Ross.
Yes, ma'am.
And Mr. Ross was previously in court, entered a plea of guilty in a new offense in clause number 25 DCCR 1310 to evading arrest or detention with the use of a vehicle. And then in clause numbers 24 DCCR 1198 and 1199, there were motions to revoke probation. And he entered pleas of true. Let me go figure out which. Pull that up real quick. Looks like he pled true to counts 1, 2, 6, and 7, which is the new evading arrest or detention. Well, there's okay, so evading arrest or detention with the use of a vehicle, and then also the evading arrest, the misdemeanor, from June 13th. He pled true to both of those. Pled not true to a possession of a marijuana case, not true to possessing marijuana, not true to never becoming intoxicated, regarding a drug patch positive for cocaine, and then pled true to 6, which was that he was out past curfew at 1:39 a.m. on June 13th, and also that he's behind in his court assessed fees. And those were all the same in those motion to revoke cases. 1, he's on probation for evading arrest or detention with the use of a vehicle. And these were 4-year deferred probations from December 18th of 2024. And the second one was deadly weapon in a penal institution. So all 3 of these are 3rd-degree felonies. We've got 2 motion to revokes, 1 new case, cap of 8 years on all of them. Okay, Mr. Burbank, while she's checking that, you may proceed with argument.
Your Honor, at this time, I'd like to call the probation officer real short, couple questions.
Sure. Good morning, Ms. Carthen? No.
Ms. Malver.
I'm sorry. Would you please raise your right hand? That's who did the PSI. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
Police court, for the record, could you state your name, please?
Sunny Malver.
Speak
And
up,
ma'am?
please, ma'am.
Sunny Malver.
Thank you.
And you're the probation officer for Mr. Ross?
Yes.
How long have you been his probation officer?
Not long at all. I think I've got, I'd only been seeing him 2 months since the admin unit.
Okay, and so 2 months from today, back?
Yes.
Okay.
Since-
And have you gone out to see him or talked to him?
Yes.
And when you went out to talk to him, what were your impressions of him? I know he was in jail. Was he respectful?
Yes. He was respectful.
Okay. And you know that the court now has to decide whether or not to send him to TDC or to continue him on probation. Right? You understand too that he was on probation for evading with a motor vehicle, and approximately 6 months, 5 months later, he's arrested for the same offense. Is that how you view it also?
Yes, sir.
Okay, can you explain a little bit about what his strengths are that you've seen very briefly?
So dealing with probation, he's pretty mild mannered than me. He acts respectful, but in the real world, I feel like he has some issues.
Okay, and what issues would that be?
Anger. And I feel like he's confused. Like most of the time when we're in probation, he calls his mom, and I don't feel like he can really understand the gravity of probation.
Do you take that because of his age, or do you think that he's just defiant?
I don't think it's age, or it could be a mix of both, but
Okay, how about do you have any learning disabilities that you remember that could also affect his judgment?
I think he's on disabilities.
Okay, and what would he be on disability for, from your understanding?
I think it was on my disabilities.
Knowing all that, could that be one of the causes for the way he's acting?
Yes, it could play a part.
Was he ever given the opportunity to go into any of the probation programs that could be possible to address these issues?
They're doing things happening too quick.
And in order to allow him to see if you can't straighten him out. But he was reporting.
Yes.
And doing all the other things, but the new offense happened too quick before
It really works probation.
anything at all.
Maybe ISF or like augmentives.
I mean, in-house, it has to be something attached, don't you agree?
Yes.
I have nothing further to do.
Thank you.
Just a couple questions.
Sure.
Ms. Malbrough, as Mr. Roth's probation officer, whether you were in direct supervision of him or taking over the file from another officer, have you had an opportunity to review the entirety of his file? And do you know?
I need you to speak.
Yes,
up,
please. And do you know that when the new offense occurred, and which he has pled true to on June 13th of 2025, was he wearing a drug patch at the time?
Yes, ma'am.
And based on your review of those records, do you find that the drug patch at that time on that date showed that it tested positive for cocaine?
Yes.
And would that have also been an additional violation of his probation?
Yes, ma'am.
And is that also an issue that was trying to be addressed both with the drug patch and with the underlying original probation?
Yes.
Do you also know or happen to know that the officer involved in the courtroom recall from the new evading has now been relocated to Dallas, but the court will recall the video that you have reviewed previously? Have you had an opportunity to briefly review those offense materials? And you know that to be a very egregious high-speed evading through all parts of Jefferson County.
Yes, ma'am.
And would it be your recommendation to continue Mr. Ross on any kind of probation at this time, or he be revoked by the court?
Not this.
Any
other questions of this witness?
Witness, Judge.
Any other witnesses?
Just Mr. Ross.
Mr. Ross, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Please, the court. Just for the record, state your name.
Kevin Roth.
And Kevin, state, the court needs to now decide what to do with you, right?
Yes,
Simple
sir.
terms. Send you to the penitentiary or possibly give you a second chance. What would you like this court to consider?
Give him a second chance.
Okay, well, what do you base that on?
Like ISF?
No, okay, but what do you base that on? What good do you have to say that I possibly will succeed?
Got a job. When I get out, I got a job. 3 jobs lined up for when I get out.
You have no place to stay.
Got a house.
You have 2 parents that are very disappointed in you, but they're still supportive, correct?
Yes, sir.
One of them actually works for a prison system, don't they? Mom,
Yes, sir.
she knows what happens in there.
Yes, sir.
And has she ever indicated to you that you're not penitentiary material? That
Yes, sir.
is that it's not a good place for you.
Yes, sir.
Well, tell me why, once this court gave you a second chance, that you decided that you wanted to go and get in a car and try to evade a DPS officer.
You can say it again.
Why did you make that decision after this court gave you a second chance to get behind the wheel of a car and try to, I guess, get away from a DPS officer? Why didn't you stop?
That I would, it was like I was I was the wrong place, wrong time. And I was.
Did you really think you could?
How were you, hold
Oh,
on.
sorry.
Huh?
Think about your answers very carefully. What does being at the wrong place at the wrong time have to do with this insane chase that you went on? Insane. I mean, 127 miles an hour crazy. What does that have to do with being at the
I
wrong
was
place?
the wrong crowd at the wrong time. Like,
So the people in your car were the wrong crowd?
yeah, like I was just hanging with the wrong people.
And that's what made you run from the
When I
car.
stopped, they just were like, nah.
Okay.
It was just intense. Like I stopped for them and they looked at me and was like, nah, don't. It just,
Because y'all were all doing stuff you shouldn't have been doing in the car. Right?
no, man.
No?
I was coming from the house going to get something to eat.
Okay. Go ahead.
Are you asking this court to consider giving you a second chance at putting in you some type of program?
Yes, sir.
Is there anything else you'd like to tell the court?
Like how she brought up the write-ups. I just was,
I'm gonna address that. Let's bring up the write-ups. You have 15 pages of write-ups. Why? Oh, there's another one. It's just on the.
One's yours, one's Ashley's.
like the last few write-ups, like it was just defending myself.
The last write-up you got is because you were urinating on something outside at the jail.
Said you were urinating by a door by the rec yard on Hughside.
When this was,
Then walked
March
down the
10th.
sidewalk, observed you, in fact.
It's today. That's today.
That's today.
they must have got the wrong person.
So this morning at 6:40 this morning,
Yeah, they got the wrong person. I came out of the dome at 7 o'clock, 7:02 on the dot. They woke me up late. She must have got whoever wrote it got the wrong person.
Ms. Malfino.
Judge, I don't really feel the need to tell the court anything that I know you already know. This wasn't his second chance. This was his third chance. Now he's asking for about a fourth chance. He squandered those opportunities, and then while awaiting your sentence, he cannot behave. I don't think that there's any reason to sentence him to anything less than the 8 years. The court previously rejected a 5-year offer, and I think obviously that was a wise decision, and I'd ask for 8 on all of them.
Judge, there's no excuse for what he did. It could have turned out very bad, doing 100+ miles an hour. Thank God it was at night with not much traffic, because he could have lost control of the car. He does have some
He
mental
did.
health.
He crashed.
No, he didn't crash.
Crashed out at 2225 Salisbury.
I saw it
Drive.
parked in front of the house. He actually ran into the house.
And climbed up into the ceiling and had to be brought down at gunpoint.
He didn't crash. He drove home.
Okay. Mr. Ross, so what I'm looking at over here and reminding myself of, just because it's been a little bit, is several things. One, the underlying offense that you were placed on probation for in the first place, the evading arrest or detention with
Yeah.
use of a vehicle, where you ran from the cops in a car, you did crash in that one. I think with another vehicle, but anyway, you had a gun on you. And so then you get probation and not, what, 5 months later, something like that. You're out while you're on probation at almost 1 o'clock in the morning in a car with 3 other people. One's a juvenile. There's marijuana in the car. There's an AR pistol in the car. And you run starting at 9th Street and 9th Avenue and 41st Street and end up with DPS, Jefferson County, Port Arthur, Groves, and Nederland all having to be involved in a high-speed chase that went, you were blacking out, you're turning your lights off. I mean, it's just crazy. You're already on probation for the same thing. And then you do it, and you do it really bigger this time with a gun, hanging out with the wrong people. You are the wrong person, right? You can't say that you're hanging around with the wrong people when you keep being a part of that. It's not their fault. You were driving. You were out with them with marijuana and guns doing who knows what. Then you get in our jail and act like an idiot in our jail. And I don't agree with Mr. Burbank that just because you're in jail and it's a difficult situation that there should be some kudos given because there's a bunch of guys living together and you can't get along. You are getting along. You're gambling. You are getting, I mean, it's just the disrespect, the not following the rules just shows you got your opportunity on probation, chance one. You've already had an unlawful carrying a weapon misdemeanor that you were given 6 months deferred probation for. You've already had a resisting arrest back in 23 that you got a probation for. A possession of a dangerous drug, you got a probation for. That one's pending now, a motion to revoke. So you've been given those opportunities. Then you get an opportunity on a felony, 2 felonies, and now you've got another felony. So continuing probation, it's not.
I can make an announcement.
Can you make a comment?
No, hold on just a second. Okay. So, I've just received verification of the incident this morning from the supervisor that they're saying that it was in fact Mr. Ross who was written up this morning for the infraction that I already talked about. All right, Mr. Ross. What do you want to say?
About the write-up situation that you just said. The write-up that I get in the jailhouse, it don't be because I gamble. Like they play stuff at the table,
Mhm.
and I'm just at the table watching.
Right.
Everybody just get wrote up. We in the day room. It's the day room.
Right.
So everybody that's in the day room watching.
Like you were in the car and you're just around all the bad people. It's always somebody else's.
Then the disrespect, every write-up they write, they put disrespect stuff. You only got to say nothing. Like when I try to plead with the write-ups with the gambling, I plead to them. Like, look, it wasn't me gambling. They'll agree to it, and then they still put it in the system. Once it's in the system, they can't take it out.
So when they put a write-up that you're disrespectful, they don't just put the word disrespectful. They put the specific stuff that was said.
Yeah.
Yeah.
So when we got wrote up, I go to the desk, tell them like, look, that wasn't me gambling.
And you said it like that, really respectful, like you're talking to me. That's how you talk.
I said, that wasn't me gambling. They like, nah, we're not trying to hit it. You was in the group watching, so you're getting wrote up with them.
Mm-hmm.
But we're in the day room together.
Okay.
The disrespect, the write-up that you read to me last time when he said I called him a B word.
Mm-hmm.
The lieutenant verified ran the cameras back and saw that I didn't tell him then
Okay,
and dismissed the write-up.
okay. So if you keep getting in trouble for sitting around watching other people gamble, and it doesn't happen just one time, but you keep getting written up for it, at what point do you learn to go sit somewhere else?
When it's the day room, we 50 deep in the day room. We watching TV, getting on the phone.
Not everybody that comes in front of me is getting in trouble for gambling. There's somewhere else to go to not get yourself in trouble when you're looking at going to prison.
Try to sit on my bunk. Fights come.
Okay.
I would.
All right, at this time,
Wait.
Mr. Rawson, cause numbers, and excuse me, cause number 25 DCCR 1310, which is the new case. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1198, find sufficient evidence to find counts 1, 2, 6, and 7, Your Honor. Counts 1, 2, 6, and 7. You entered those pleas freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. And sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24 DCCR 1199, also find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a deadly weapon in an institution, penal institution. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I've handed you the trial court certifications. This shows that these were agreements I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Burbank. Good luck to you, sir. You can go back with the bailiff.
That's all I had.
Thank you, Mr. Burbank.
Excuse me.
Yes, sir.